Hey there, I'm attorney Jason McGrath with the law firm of McGrath and Spielberger. I've been practicing law since 1996. I practiced in a number of states, focused here in North Carolina, and also my firm practices in the other states that you'll see above my shoulder here. In any case, we're talking about mediation today. And if you're watching this video, it might be that you've never been to a mediation and are potentially going to be involved in one, want to know what to expect, that sort of thing. Many different types of cases go to mediation. Sometimes mediation is court ordered. Sometimes mediation is voluntarily entered into by the parties. And again, as I said, it can involve the smallest case to the largest case. And quite frankly, the larger the case or the smaller the case, those two ends of the spectrum tend to often have mediation ordered more frequently. A lot of small claims courts actually order mediation to occur. And a lot of the higher level courts, as far as the amount in dispute, will also order that it occur, but sometimes it's just voluntary. Mediation typically, in 99% of instances probably, does not result in any kind of order or mandatory decision or anything like that. There is such a thing as binding mediation, but it's really rarely used. I don't know that I've ever even heard of it actually being used. I know that it exists. I've done many mediations representing a party, and nobody has ever suggested a binding mediation. Arbitration is different. Arbitration is where you're basically going to have almost like a private trial. And arbitrations typically, not always, but typically are binding, where you're going to go and perhaps have one or three arbitrators that are going to listen to the evidence and testimony and hear arguments and make decisions. Mediation usually is more of a negotiated settlement type process where you've got a middle person, a neutral mediator, who is going to help you hopefully resolve your differences. And mediations really can go in almost any kind of format or procedure or process, but typically what happens most often is the parties, or sometimes just the lawyers, will meet with the mediator in a conference room, for example, and often both sides will have a chance to go ahead and present their case or their argument or whatever they want to say. And in many cases, this might be the only chance you have to sit down with the other side, sometimes including the actual parties, not just the lawyers, and actually get to speak to them. So I would always consider, and do always consider, whether I'm going to, amend what I might say based on who's in attendance. So if the other party is there, it's my only chance to really kind of talk directly to them without their lawyer running interference or interpreting things that I might actually say. I will perhaps present our position in our case differently than if it's just the lawyer. But in any case, both sides, or all three or four sides, will give their presentations and then often break up into smaller rooms. And the mediator typically will kind of go back and forth between those rooms and have discussions with the individual parties and their lawyers. Now, the best mediators usually are those who are proactive. The worst mediators, or I shouldn't say the worst, but mediators are usually more effective if they are somewhat proactive. So I typically want a mediator who's going to point out strengths and weaknesses of each side of the case, or all the sides of the case. Somebody who's just playing messenger really isn't all that helpful. So if I'm saying to the mediator, well, go tell Mr. Smith this and go tell Mr. Smith that, I don't really need a mediator charging a couple $100 an hour to do that. What I hope is that the mediator might go on the other side and say, look, I just talked with Mr. McGrath and his clients, and I can't tell you everything that they discuss with me because part of it is confidential, but I can tell you that we talked about this particular issue. And as far as the damages you're claiming, here are some reasons that they put forth which make a lot of sense to me why you're not going to be able to recover those damages. So let me just explain that to you, and I just want to make sure you're considering that. And then, the mediator might come back to our room, 20 minutes later or 2 hours later. It's not usually 2 hours, but, usually more like 20 or 30 minutes. Say, hey, look, I relayed your message. I shared some of my own thoughts with them. And in response, they have lowered their settlement demand by $20,000 or $200,000 or whatever it might be. Or if you're on the other side of the coin, it could be that that we're sitting here waiting for the mediator to come back, and he or she comes back and says, well, you know what, they've now agreed to pay $25,000 more, or they've actually agreed to pay the amount you were asking for, that kind of thing. So that's what mediation usually is. A really important aspect of mediation is how you're going to resolve or end mediation in a formal sense. If you've reached a settlement, typically you're not going to be able to draft up every settlement detail there at mediation. People usually, when they reach an agreement, they just want to leave. But you need to make sure that you have settled on the main points at least. This is really important. So what we try to do is at least get a general agreement in writing and signed before we leave mediation that covers the key points. There have been many, many cases that have settled at mediation only to then fall into dispute over what the terms of the settlement were. So you need to at least get the key points down if you've reached a settlement. If you haven't reached a settlement, you have to decide in conjunction with the mediator sometimes whether the mediation is going to be considered done, finished, and you've reached an impasse, or whether the mediation is going to be held open, which means that you can either meet again in the future, and you can really always meet for a second mediation. But if you have a court-ordered mediation, the judge is going to want to know if you completed mediation. So if you've gone for a full day and you haven't resolved the case, it might be that you want to say, well, we did mediate, we finished mediation, we reached an impasse. We can still negotiate later or have a second mediation, but we want the court to know that we did mediate. So mediation usually ends with either a settlement, that's number one, and usually the best result. Number two, an impasse, where you've done your mediation, you didn't reach a settlement, unfortunately, and so you're going to just go forward with the case and maybe go forward with some additional settlement negotiations in the future. Or number three, the mediation is held open, which means that mediation is ongoing. And sometimes mediation can be ongoing for weeks or even months, and maybe the mediator will engage in a series of phone calls and emails with the two sides and help them to be that hopefully proactive, neutral middle person that can move the sides closer to a negotiated resolution. So trials are fun for lawyers in a lot of ways. They're also very stressful. For lawyers and everybody else involved, they're very expensive. And so in most cases, a settlement is probably your best resolution, but that only can happen and only can be true if the other side is willing to meet you, maybe not halfway. It really depends on the facts and circumstances of the case. But settlement is at least something that you can control. You can say yes or no. And I've heard many, many judges, especially on the eve of trial, tell the lawyers and tell the parties, hey, look, I'm willing to try this case. But if once we go to trial and once we complete the trial, the resolution is out of your hands. You've lost control. Until that point, you can still negotiate. You have control over it. So maybe you want to take control, and even if you're reluctantly agreeing to a settlement, maybe that's the right thing to do. I just had a judge, frankly, in federal court yesterday make the comment that, hey, look, resolving a case is a business decision. And no matter how mad the parties are at each other, they've got to approach it logically, or lawyers, and the judge said this, you need to make sure your clients are doing their best to approach it logically without all the emotion that probably exists, and is making a common sense, business decision on whether to resolve the case at settlement, via settlement at mediation, or to go forward to trial. So I hope that was helpful, and if you need help with your mediation or case, and it's appropriate for us to render that assistance and we reach an agreement, that's fine. Always feel free to give us a shout. Thanks and good luck.